welcome back to the legal video series presented by the Law Office of Joseph Abrams. I'm criminal defense attorney Joseph Abrams, and I answer your most common questions about federal criminal law in easy to understand terms. So let's take a look at today's question. This is an interesting question and one that is not well understood by most defendants and even some attorneys. In federal court, immediately after a guilty plea or conviction, the judge will refer the defendant to the federal probation office for an investigation and report. Sentencing then will be set out a number of weeks to allow the probation office to conduct its pre-sentence investigation, which includes a personal sit-down interview with the defendant. I'm often asked whether or not the attorney should accompany the defendant to the pre-sentence interview. The answer is unquestionably yes in every case. The pre-sentence report contains an extensive amount of important information about the defendant's personal history and the circumstances of the offense. During the interview, the defendant will be asked a number of questions about their personal history, including their childhood, family circumstances, mental health history, substance abuse history, education, and employment. A federal criminal defense attorney best serves their client by allowing the defendant to openly discuss these issues in detail. This allows the court to see the defendant as an individual and to impose a fair and just sentence based on the needs of the defendant. In most cases, defense counsel should not allow the defendant to discuss the offense or their criminal history. The probation office will conduct its own investigation into the offense and the defendant's criminal history and document all of it in the pre-sentence report. If there is something that needs to be explained or corrected, defense counsel can do so with a court filing. Many attorneys, wrongly in my view, will not allow their clients to discuss the topic of substance abuse. The problem with this is that if a defendant's substance abuse history is not documented in the pre-sentence report, they are likely to be deemed ineligible for drug rehabilitation programs while in custody, including some programs that can result in a reduction of their sentence. In conclusion, the federal pre-sentence interview is an important one-time opportunity for the defendant and defense counsel to have a say about what will be included in the pre-sentence report, an opportunity that should not be missed. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope you found it helpful. And we'll see you next time when I answer another of your questions about federal criminal law.